Hello everyone, welcome back. Today we'll be talking about the Dangote Refinery and labor union agitations, the law and what you must know. The refinery is one of Nigeria's biggest industrial developments in the oil and gas sector and is being in the headlines recently due to labor union agitations. It was indeed a very topical issue, not just because of the headlines, but because this refinery is a national asset that cannot be ignored. And anything that happens here can affect Nigeria's economy, fuel pricing, fuel availability, jobs, and industrial harmony, investors' confidence as well. As we dive deeper, we will start by looking into the scale of the Dangote Refinery project itself. The refinery is located in the Lekki Free Trade Zone of Lagos and is the largest single-train refinery in the world. Here are the numbers. It has a capacity to refine 650,000 barrels of crude oil per day, more than enough to meet Nigeria's domestic demand for petrol, for diesel, kerosene, and jet fuel, also known as Jet A1. As a matter of fact, we understand that Dangote is planning to scale its efficiency levels to about 700,000 barrels per day. The refinery was built at an estimated cost of over $20 billion with an integrated petrochemical complex and fertilizer plant alongside. It's expected to save Nigeria up to $25 billion annually in foreign exchange spend, which amount was previously being used to import petroleum products into the country. And even more importantly, the refinery, if well managed, can make Nigeria a net exporter of petroleum products to other countries. Already, Dangote for the first time is already exporting products to the US, to Saudi Arabia, and other countries. The refinery already employs thousands of Nigerians directly and indirectly, and once it ramps up fully, it's projected to create over 100,000 jobs across its value chain, from crude supply to logistics, maintenance to retail distribution, and the thousands of drivers required to drive its trucks. Recall that Dangote has already procured about 4,000 CNG-powered trucks to deliver products to four stations across the country. So, when disputes like strikes and lockout arise at a facility of this scale, it's no longer a private matter. It becomes a national concern. What are the reasons behind the union agitations? NUPENG and PENGASAN, two major unions in Nigeria's oil and gas industry, have raised concerns. The concerns center around union recognition for PENGASAN, whether workers at the refinery can freely join or form union of their choice, and whether management of the refinery has been fair in responding to such efforts. There were also the allegations raised by members of NUPENG alleging anti-labor practices and alleged growing monopoly in the downstream oil sector. Dangote, on the other hand, says it has continued to comply with all laws within Nigeria and to respect the right of workers. These are legitimate questions because while the right to hire and fire, subject to lay-down processes, is recognized in Nigeria, the law also recognizes the right of freedom of association and to belong to a trade union of one's choice. Specifically, Section 40 of the 1999 Constitution guarantees the freedom to form or join any association, including a trade union. It says that every person shall be entitled to assemble freely and associate with other persons, and in particular may form or belong to any political party, trade union, or any other association for the protection of their interests. The Labour Act provides for fair labor practices and conditions of employment. Also, the Trade Unions Act governs how unions are registered and operate legally in Nigeria. So, yes, workers have the right to join unions. That's not in dispute. But those unions, and indeed the employer, also have legal responsibilities under Nigeria's labor laws, especially during a dispute. In determining these responsibilities, we will look at what the law says about industrial disputes and strikes. It is important to note that industrial dispute is envisaged under the law, and robust provisions were made on how these disputes should be resolved under the Trade Dispute Act. This law sets out the step-by-step process for resolving any labor disputes in Nigeria, whether it's about wages, welfare, or any form of grievance. According to sections 3 to 18 of the Act, the process for dispute resolutions are as follows. The employer and workers or their unions must first try to resolve issues through discussions and consultations. If talks break down, the dispute must be formally reported to the Minister of Labour and Employment. The minister will then appoint a conciliator to mediate and try to get both sides to reach an agreement. If conciliation fails, the minister then refers the matter to an industrial arbitration panel, which issues an award. Now, if either side is unhappy with the award that has been issued, it can then refer the matter to the National Industrial Court for a binding decision. Now, here are the key points. Under Section 18 of the Act, no worker or union may lawfully go on strike and no employer may lock out workers until all these steps have been completed. So, if any union calls a strike before completing these legal processes, that strike is illegal and such a person may be prosecuted for this offense. It is often the case that prior to exhaustion of these steps and processes, a union may give few days notice prior to embarking on a strike in violation of the procedure mentioned above. This would be illegal. Sometimes, a union may even picket and shut down a company's operations, lock the gates, prevent all staff from entry and exit from the company, right? These would also be illegal, especially when you prevent workers that are not union members from doing their work or entering or exiting from work premises. This may actually amount to false imprisonment and a violation of the rights to freely associate of the non-union members. And if management shuts down operations or victimizes employees mid-process, that's also a breach of fair labor practice. The law applies equally to both sides. More interesting is that if the workers are engaged in essential services, Section 45 further mandates them to provide at least 15 days notice of intention to strike. Essential services under the law include the public service of the federation or state, persons employed in the armed forces, any service, whether public or private, dealing in electricity, water or power or fuel of any kind, telecom services, ports and harbors, including transportation, health services, banking services, and a few others. Now, because of how crucial essential services are, the Trade Dispute Essential Services Act makes an abridged dispute resolution process to empower the minister under Section 5 to immediately refer a trade dispute to the Industrial Arbitration Panel to prevent disruption to the economy or the smooth running of any essential service. Interestingly, Section 1 of the Act empowers the President to prescribe any trade union or association found to have engaged in any act capable of disrupting the economy or any essential service. In addition to prescribing the union, the assets of such a trade union shall be forfeited to the government. The leadership of the prescribed union will be barred from holding similar positions in any trade union whose members also work in the essential services. They may even be imprisoned for the offense if convicted for up to 5 years. Section 4 makes clear provision in that regard. Now, to balance the conversation, it is very important to consider the rights of the employer as well. In this case, Dangote. Now, Dangote, as an employer, also has a right under Nigerian law. The company has a right to hire, to train, manage, and if necessary, terminate the employment of workers, provided it is done fairly, transparently, and with valid reasons. Why is fairness and valid reasons necessary? It is to show transparency, especially when the employer is deemed the stronger party in most employment relationships. The common law position used to be that an employer can fire at any time for good reason, bad reason, or for no reason at all. However, international labor conventions and best practices have now mandated employers to state valid reasons for the termination of an employment relationship. This is by virtue of the provisions of Section 254C of the Third Alteration Act and Section 76 of the National Industrial Court Act. The National Industrial Court has exercised its jurisdiction to abolish the common law rule by which an employer can terminate unemployment for good or bad reason or for no reason at all. The above provisions empower the National Industrial Court to apply Article 4 of the ILO Convention number 158, which provide that valid reasons must be given for termination. Nigeria is now a signatory and has ratified the provision of this convention. The usual reasons for termination will typically be on grounds of non-performance, misconduct, lack of capacity, or even based on operational requirements of the employer. In this case, Dangote said it was letting go of 800 workers due to operational restructuring. Under the Labour Act and the established case law, an employer can determine the structure and staffing of its operations as long as due process is observed and workers are not discriminated against for their union activities. Employers also have the right to expect industrial peace and a workplace free from disruptions, provided they are not infringing on legitimate employees' rights. So, Just as unions seek recognition, management also seeks stability and order, especially in a multi-billion-dollar project that carries national importance. It was therefore not surprising that stakeholders within the government and private sector quickly intervened to ensure there was no further escalation and negative impact on the economy. Why this refinery must work? The success of Dangote Refinery is bigger than any one company or one union. It is tied to the future of Nigeria's energy security and independence. That's my opinion. Dangote has invested a lot of money to bring the refinery to commercial operations. He has also invested in many other industries and employing thousands of people. It's therefore not surprising for the presidency to refer him as an institution and not just an individual. That is a very deep and insightful statement. And we all know why this is crucial. Nigeria spends about 40% of its foreign exchange on importing refined petroleum products prior to 2024. The refinery could reverse that, saving billions annually. It would also help stabilize fuel supply, reduce subsidy pressure, create export earnings for the country. Africa will finally have a world-class private refinery capable of meeting its continental demand. So, industrial peace at Dangote Refinery isn't just about workplace relations, it's about national economic stability. What's the way forward? Both sides, the unions and the management, must continue to engage constructively and lawfully. The unions must follow due process under the Trade Dispute Act. Otherwise, they may force the hand of the president to bang the big hammer. Dangote must also recognize the freedom of association provided for under the Constitution, and the Ministry of Labour must continue to act swiftly under Section 5 of the Act when urgent and serious matters are concerned to prevent disruption to this strategic national asset like this refinery. Dialogue, not confrontation, is the key. At the end of the day, everyone wants the same thing: a fair workplace and a working economy. When the three L's, law, labor, and leadership, work in harmony, Nigeria wins. Ultimately, everyone wins. Thanks for watching. Don't forget to like, share, and subscribe for more energy related content. I am Babatunde, and I will see you in the next one. Thank you.